good faith. And if the court listens to the histrionic from the petitioners, the courts will note that the application is not made in good faith. It is tied to an intention to extend ex parte orders that advantage the petitioners. The petitioners are intent, my lords and my lady, on scuttling the bench and scaring them away from sitting so that they can have open-ended and irregular orders issued in Kerugoya by Justice Richard Mongo. Then they went to the second act of actually filing a complaint to the Judicial Service Commission submitted to Isaac Wamasa and duly acknowledged, so that this court can be scared away and run away. My lord, then the scheme is not complete. My lord, Judge Ibrahim, at page 31 of the Gladys Boss Sholei decision, stated, my lord, that the threshold for impeachments cannot, for recusal cannot be so low, and every allegation made of any form of bias must be proved through credible evidence. And then I dive straight to section 11 of the Oaths and Statutory Declarations Act. The petitioner's affidavit. The petitioner made a false affidavit through a deponent who swore to factual issues that the petitioner then attempted to withdraw in court. My lord, that not only invites a criminal sanction under section 11, but what is more important, my lord, is that false affidavits are no affidavits and must be struck off. Because the penultimate paragraph in an affidavit, my lord, swears to the truthfulness of the whole document. Where therefore, my lords, any part of that document is false, the affidavit must be struck off. My lord, we further submit that to both applications, my lord, that are before you, parties having been unable to meet a threshold that would warrant the disqualification of all the judges sitting in this bench, that the applications must fail. I have no doubt, my lords, that we have cited relevant authority. We have cited the authority in Jackson, Molalu, and others, a court of appeal decision on the threshold that learned friend Senior Counsel Hamina wants to lower. He invites the court that at every mention of the possibility of bias, that the court downs its rules. My lord, if that were the case, no judicial proceeding would be conducted in this country. And learned friend, Senior Counsel Professor Gideon, I told you of the number of students that he has taught. I think I've taught more young counsel in this room. And it would be impossible, my lord, if association by way of sharing a classroom or teaching were a threshold or a test for bias, that judges would recuse themselves, my lord. No judge, my lord, would sit on any bench to hear any case, because we are all extracted from the same academic background and a daily trend. Unless my learned friends are saying that. Yes, my lord, in response to the suggestion that the Honorable Justice Lima attended a wedding of the Speaker of the Senate, my lord, the Speaker attended the wedding of the Honorable Justice, my lord, the Honorable Justice Amason Kingi, is a peripheral party in the proceedings. Indeed, if you look at the proceedings, my lord, what we have in the proceedings is not Amason Kingi as a party in his name. It is the office of the Speaker office who is a defendant or a respondent in these matters. But number two, my lords, the Honorable Speaker Kingi merely presided over the proceedings in Senate and was not a voting member in the sitting of Senate that led to the impeachment of the former Deputy President. My Lord, the Honorable Kingi has not taken part in the appointment of this bench in any form. But clearly, the petitioners are clutching on straws, and every attempt at ensuring that this court does not proceed seems to be falling by the wayside. I urge the court and I invite the court to consider this application for recusal as another attempt to frustrate the processes of this court and to ensure, my Lord, that this bench does not proceed to dispense justice that ought to be dispensed expeditiously in line with the Constitution. I pray, my Lord. And my Lord, on the appointments of judges, my Lord, clearly, if peradventure the argument on conflict extended to who appoints, my Lord, the President appoints all judges, and is a party. I think they should have added that ground, perhaps, because the President appoints all judges. But that cannot be a cause for a party seeking a recusal, my Lord, because the President, in performing a constitutional mandate, just like, my Lord, the CS Environment Soipantia exercised her statutory mandate in appointing Florence as a board member, my Lord, cannot be a cause or a basis for seeking or asking for conflict. My Lord, soon parties will then apply for recusal on the basis, my Lord, that two judges or a litigant and a judge belong to the same community. Thank you, my Lord.
Sorry, none of them is quite near me, so I think I will. Thank you. Thank you very much. Just a brief rejoinder to the application, and especially in view of what has actually been disclosed after the arguments. And my lady and my lords, I would be urging you kindly to actually go through these voluminous decisions we have given to you, because part of what some parties are submitting and saying it falls on all fours in relation to the matter before you.